Hi, everybody. Thanks for being here. We appreciate it very much. I'm Tim Andersen, the appraiser's advocate, and I'm here today with Peter Christensen, Esquire. Peter has advised appraisers for many years. He knows a lot about appraising. He's involved in many facets of what goes on in the appraisal world. Now, Peter, thank you, first of all, for being here. I appreciate it very much. Now, a little quick background. You recently took a job as general counsel and chief compliance officer with BBG. And give us a short synopsis of that before we get into our topic today.
Yeah, that was in August where I started working with BBG. So that's a national commercial appraisal firm. Doesn't do any residential really. Maybe there's a couple of assignments in a year or something that occur, but it's oriented to commercial. And so in the past, when I was working for my regular clients, I would say my past work was divided about 50-50 between residential appraisers and appraisal firms and also AMCs and then commercial. So now I'm more devoted to commercial, but I still definitely have my head into issues affecting residential because among other things, one of the things I still do outside of BBG is I do a comprehensive legislative report for appraisal firm clients, for AMC clients, where I'm reporting on all like the latest regulation changes or law changes affecting the residential side too.
Okay, so given that, you're very up to speed on what's going on in appraisal world. So let's talk about that. Now, there's a lot going on in appraisal world, but we're going to keep our discussion today relatively narrow. The question has come up, and you've looked deeply into this. This is something you've investigated for your clients as an attorney. The concept of, okay, who owns the appraisal? Who owns the data? Who owns the report? What happens to it? What does USPAP say about it, et cetera, et cetera, et cetera? So let's start off with a general question and we'll narrow it down as we get into this. But let's talk about it. Okay, who owns, let's talk about this one first. Who owns the appraisal?
Um, Let me start with what would happen if you asked ChatGPT who owns your appraisal report. Chances are, because I've done that, that ChatGPT would hallucinate and tell you, like, give you a simple answer. And if your appraisal report were for a bank, ChatGPT, when I asked it, told me that the bank owned the appraisal report. And that's not actually the case. So when we're talking about an appraisal report, let's back up a little bit. Who are we talking about as far as the author of that report? You and I think we're talking today about like appraisers who work independently. They're not employees of banks. They might be an employee of an appraisal firm. That would change things a little bit here. But for the most part, we're probably talking about appraisers who work on their own as independent contractors to banks or to AMCs and to their clients. So when you work on your own, when you're an independent contractor, what copyright law says is that you, as the author of that report, that appraisal report, use the author of it. That's the starting point. You own it. You own the copyrights to your work. And there are actually cases out there where appraisers have sued other parties saying, hey, that was my appraisal report that you copied and pasted from, or you just wholesale copied and did something else with it. There are actually cases out there where appraisers have litigated that, aggressive appraisers who are about protecting their rights. So the law is that you, as the author of your appraisal report, own it. Now, if you work in an appraisal firm, your employer owns it. But when you are independent and delivering appraisal reports to, say, banks or to AMCs, the starting point in the law is that you own that report. Now, there's a lot of other details that then get filled in. And maybe we'll get into some of those details because uh, appraisers do frequently give away or sell a lot of the rights that they own to their appraisal reports. They authorize other people to use their appraisal reports. They authorize their clients to use them. So maybe we'll get into that a bit too. But the starting point is the appraiser owns their report.
Okay, you mentioned litigation, and I think you're talking about the Vinings case, or at least one of them. Can you give us a little background on Tim Vining, his appraisal report, what happened to it, and what the court eventually decided?
Yeah. I like that case. First, yeah, I'm here in Montana, and this case took place in Eastern Washington, in kind of a area of the country that resembles Montana in some way. But the properties that were being appraised in this case were hop farms. So very large commercial hop farms. So hops being used as a key ingredient in a lot of good beers. And that's the other reason why I like the case. And so in this case, the appraiser had a great assignment for a lender. The assignment was to appraise these various hop farms. This is going back to right around probably 2002 or so, give or take a couple years. So that the assignment back in 2002 or so was to appraise these farms. The fee back in 2002 even was $20,000. So it was a nice fee for this commercial appraiser. And he produced an appraisal report that was 250 pages, had a lot of detail in it, had photos in it, had a lot of descriptions of the hop farms that were being appraised, had very like a lot of research by the appraiser. And so what happened was the appraiser completed the report for his client, again, the lender. But then one way or another, some real estate agents and brokers, real estate brokerages got a hold of the report and they were selling the properties. And they used parts of this appraiser's appraisal report in their marketing of the property for sale. So they copied and pasted or whatever they did, used words, used descriptions right out of the appraisal reports as part of their marketing. And the appraiser, I don't know, he was offended by that. He didn't, it wasn't his view of how his appraisal report would be permitted to be used. Certainly wasn't part of the intended use description, I would say. Probably not. And so he actually sued. The appraiser sued those agents and brokers. So he sued them for violating his copyrights to the appraisal under federal copyright law. And what ended up happening in the case was, well, the agents and brokers tried to get it dismissed. Oh, he doesn't own the copyrights, whatever, or this is, we're permitted to do this for one reason or another. Well, the court did rule on a summary judgment motion that the appraiser owned a valid copyright to the appraisal report. Now, the appraiser here had actually registered a copyright. So he'd actually gone to that trouble, but that's not even a key here. That's not the key. Like you still own your appraisal report, even if you haven't recorded a copyright. So the court did rule he owned the copyrights. The court wasn't so sure about some other things in the case. What it wasn't so sure about is, did the appraiser somehow give away the right? Like by giving the report to the lender, and then maybe the lender could have given the report out to the agents and brokers. Did the appraiser like give an implied license, it's called, like an implied right to those parties to use the appraisal report? And the court wasn't so sure about that. So it denied the summary judgment on that, and said, okay, we're going to have to litigate that going forward. Was there a license to use the report? But the important takeaway there was the court was saying, let's look at contract law to determine, did the appraiser give away these rights? So that's contracts, really important here. That's a big takeaway from the case. What happened in the case then was, okay, the appraiser owned the copyrights. The agents and brokers, I think, kind of made a determination. This isn't looking so good for us. We probably don't have that license that the court spoke about implied to use the report for the purposes we used it for. And at the end of the day, the agents and brokers agreed to a judgment. They stipulated to a judgment and agreed to pay that appraiser $50,000 in damages in a judgment that was actually entered back in 2005. So it's an interesting case for a number of reasons, but the key takeaways are contracts really matter here, like this implied license kind of contract that the court was talking about. And the other big takeaway is, yeah, appraisers own the copyrights to their appraisal reports.
Okay, let's look into this a minute. Okay, so the defendant's name was Tim Vinings, and he did the appraisal as you indicated. The client was either selling or refinancing basically their business, and it got sent to a lender. Somehow it got into the hands of the brokers, and the brokers incorporated a lot of the language of the appraisal, the charts, graphs, etc., into their offering circular. Now, this is not a situation where another appraiser got a hold of it and was trying just to not do a lot of work but get a big fee. There was no other appraiser involved. There's a broker involved.
No, but I've
Now,
seen that case too. Yeah.
okay, in this case, there wasn't
Yeah.
an appraiser involved. It was
Yeah.
just the broker. Now, let's suppose that the broker had. Now, I'm assuming, and I read the decision, and I didn't read this in the decision, but I'm assuming that the broker was assuming the fair use rule. In other words, you can use somebody else's stuff if you use it fairly, which is you use it a little bit and then you put everything in quotes and you cite your sources, et cetera, et cetera, et cetera. So it sounds to me like the brokers didn't do that. They took massive chunks of the appraisal and moved it into the offering circular without proper attribution, without the quotation marks, without acknowledging the copyright, et cetera, et cetera, et cetera. Are those details correct?
Um, yeah, I think so, but I gave much thought when they copied it. Like they probably weren't thinking fair use. Um, the other thing about that, the defense that you raised, the fair use, is that it would be pretty tricky to apply in this instance because the brokers were using parts of the report for commercial purposes. The brokers are going to make money off of using parts of the report, which the fair use defense is a balancing test. There's no bright lines. Yeah, you could in some cases do that if you were transforming a use, but it's not, that's not a real clear cut defense. So I think it comes down to the agents and brokers copied and pasted without too much thought to what they were doing. And then, yeah, it was difficult for them to defend doing that.
And as it ended up, they couldn't, and they settled for
Yep.
$50,000. Okay, so that case made clear that Tim Vinings owned his appraisal report, and the broker, in abusing that right, was therefore penalized, which means that the broker gotten in touch and said, "Can we have permission?" And there would be possibly something to negotiate, and there wouldn't have been a problem had the brokers handled it differently. And you mentioned
Yeah.
contract law.
Like
Now,
you just said, they could have asked for
okay,
permission. That, as you just said, they could have asked for permission, and maybe the appraiser would have said, maybe, yes, maybe. I don't know. If I were an appraiser, I'd be a little reluctant to allow agents, brokers to use part of my appraisal report in selling the property, but they could have tried to ask for permission.
right, Tim or Mr. Vinings wouldn't have had to give it to him, but at
No.
least they could have asked. That would have been
Yeah.
the proper thing to do. Okay. So let's look at it a little bit further. Okay. The court said, yeah, Mr. Vining, you own the report. Now, who owns the data in the report? I go to the public record. I go to
Mhm.
my computer's telling me my internet is unstable. Okay. I go to the Palm Beach County Public Record and I pull a copy of the deed and I see 1234 Elm Street sold for $750,000. Okay. And I summarize that information in the report and I have a copy of the deed in my work file. Now, that is public record data. I
Mhm.
didn't generate it, somebody else did. It's
Yeah.
there for the benefit of the public. I'm a member of the public. I benefited from it. But do I, in putting that in my work file, do I now own that data? And I'm using this to lay the foundation for another question.
Yeah.
Do I own that data in the report?
Uh, Before we get into other details, the law is going to say, no, you don't own the facts, the data that you're reporting. People don't own information, especially when we're talking about true, simple facts. So the bedroom count of a house, the location. I'm talking about like physical location, whether it's address, latitude, longitude. You don't own facts and data. Nobody does, in general. There's a couple ways that that can change. Maybe we'll get into that. Um, One of the ways that can change is, okay, if you create a database, so you've put effort into it and now you've like classified facts and then put them into a big database. Okay, now you do own this database. And if someone comes along and steals that database, now we've got a problem. But then there's other ways that you can maybe or there are, you could, maybe we'll get into this. You could have a client that says, um, any work product that you create, any facts, any data that you put in your appraisal report, as between you and us, you are granting us the ownership of it. But that's a little, I see agreements like this all the time where a lender says we own the work product and the data and the facts. They don't really own the data and the facts, but that same agreement is going to say that the appraiser can't can't like be selling that data and those facts to other parties. It can't be using it for other purposes. So it does get murky in some of these contractual agreements when we get into the details of those. You can lose control, I would say, of your facts and data.
Okay. So, while facts, information is not copyright protectable in one sense, if you put it into a database of your own manufacture, of your own maintenance, etc., then the database itself could be protected. Okay,
Yes.
now let's carry this a little bit further. Um, okay, I got four sales in an appraisal report, and I send it into the lender, and uh, going through the black box of a portal somewhere, the data gets stripped out of it, and it gets put into the lender's database. Now, again, we just talked about the fact that the appraiser did not own the facts,
Mhm.
and the lender, we're going to get the intellectual property in a minute, but the lender didn't copy the intellectual property; it just copied the data for the address, the room size, the site size, etc. Just copied that data, and it's going to build its own database for purposes of comparing future appraisals. Now, is and the appraiser says, well, they can't mine my data, so I'm going to sue. What chance does the appraiser have of making that fly?
It's going to be tough if we're talking about simple data, like bedroom count was an example that we talked about. If it becomes like opinions of value, okay, now we've transcended just simple data and now there's some analysis in there. I would say that the appraiser is owning that uh, opinion of value. But so if the lender wants to assemble his database of all these bits of facts, okay, leaving everything else aside, I'm I'm thinking that the lender can do it, unless there's some other prohibition out there that the appraiser has somehow um, created. But here's the thing: if we're talking about an appraisal on a URAR, uh, the appraiser totally needs to forget about it. I mean, that's my point of view. Don't even like, no, you're not going to be able to tell your lender client, anybody that your lender client gives that appraisal to. If you look at the language in a URAR, the present version, or if you look at the one that's coming, um, the residential appraisers on those forms and the non-form have lost complete and utter control. And maybe we'll get into the words because I'm very familiar with the words in those reports. So here we're getting in again kind of to contract matters, that contracts really matter. The other way it's going to matter is because the lender client may have that statement in an engagement agreement or contractor agreement that I talked about before, where the lender client has said to the appraiser, we own all the work product. Okay, so another way that the appraiser has lost complete control over any data, any information at all, even if it transcends data in an appraisal report.
So you're talking about certification number 23, basically. So, in
Um,
other words, contract. Oh, I'm sorry. Go ahead. Excuse me.
yeah, no, yeah, I am. Well, actually, I'm talking about a different one. It's certification number 21. Um,
I'm sorry.
23
21.
is one
Yeah.
of my
I got point.
favorites. 23
Yeah.
is one of
I'm
my
sorry.
quote
Yeah.
favorites, but
Yeah.
it's 21. And what it says it on the URAR, the present one, it says that the lender client may disclose or distribute the report to the borrower. And then it also says data collection or reporting services without having to get the appraiser's permission to do that. And so that's a pretty wide grant of like any rights to use data to do what they want with it to a lender client. But then there's the new URAR coming, which is like the unform or something like that, and that certification switches over to number 23, number 24 now. The new number, so the replacement in the old one is even broader. And what the replacement says is that the lender client can disclose or distribute that report to the borrower to data collection or reporting services. And then there's other parties also. And then the new certification goes on and says anybody who gets the appraisal report as a result of the lender client giving it to the borrower or to the data collecting companies, anybody who gets it can use it for any purpose, internally or externally, without the appraiser's permission. So in the future, yeah, residential appraisers on the URAR work will have lost complete control over their data. But it's this very specific to the URAR because like yeah, now I work on the commercial side. These aren't things we typically agree to on the commercial side. So commercial side, quite a bit different. URAR work, an entirely different world here.
Yes. In entirely different. Okay. Let's talk about intellectual property. Okay. So we've gotten the information, and the appraiser amasses data on 15 sales and comes up with, okay, the GLA adjustment is $85 a square foot. Okay. Now, that is obviously the result of intellectual effort. And that is obviously the result of examining and analyzing those particular sales. And yes, it's based on public information, but the results of that public information had to go through the appraiser's analyses. In other words, it had to go through the appraiser's mind, and therefore becomes the appraiser's intellectual property. Given the intellectual property standpoint, is what 24 is going to say and what 21 says now. The equivalent of the appraiser saying, "Oh, and by the way, I'm giving you my intellectual property to do with as you choose."
I think that the new version definitely. I'd agree. I'd agree that the new version, the new number 24, and the new URAR, that the latitude of the rights granted there are encompassing what you just said. That yeah, you can use my opinion of value or my other analysis in the report for any purpose, in whole or in part. I think that yeah, I think that's what it is. And the reason this wasn't like I don't believe that this was any kind of ill intent by Fannie or Freddie with respect to this language. What it was, I think, was simply that the attorneys drafting this kind of language for the two GSEs, what they want to do is just like enable the GSEs to be able to use these appraisal reports for any purposes that the GSEs want. And in doing that, they wrote like incredibly broad language that allows many other parties to also do the same things that the GSEs would want to do. So it's just overprotective to the GSEs in amassing these rights, and it's just and like I think it's just gone too far.
Okay, and again, these are your feelings. This is
Yeah,
nothing official. No. Oh, yeah. But
no,
okay. All right.
who would?
Oh,
Yeah,
yeah.
yeah.
This is how you interpret the facts. A court may interpret them differently. Right. Okay. And another attorney may interpret them differently. Let's take a look at, for a second, data mining. A lot of appraisers have complained that Fannie and Freddie basically are taking the appraiser's own data, mining it, and then selling it back to them. Um, but given what you just said about 24, um, yeah, the appraisers are just giving it up. So sure, the client can do with it what they want to. So the issue, when as you called it, the unform comes out, basically the issue of data mining is going to go away. Do I interpret that correctly?
I think so. I think so. Yeah, that this is a wide open door for the use of data out of URARs in the future. Um,
Okay. Let's get back to intellectual property, but from a little bit different standpoint. Okay, now I've amassed 15 sales and I did the work I had to do, and I'm real happy from those 15 sales that the GLA adjustment's $85 a square foot. Okay, now a month later, I'm doing an appraisal in the same subdivision. In fact, it's 6 houses away. And I go, wow, why should I even bother with coming up with a GLA adjustment? I came up with one in the past appraisal. So I just copy it into this new appraisal. Now, in the new appraisal, have I engaged in any intellectual work that allows me to claim intellectual property? Or by cutting and pasting, am I abrogating any privilege I have to claiming that's my intellectual property?
well, I don't know. I mean, other things were going through my mind as you laid out that scenario. I mean, what you were laying out to me sounded like a different case that happened in Tennessee recently, where an appraiser first did an assignment to appraise a house for a bank, and then later got an assignment and did that assignment. Very soon afterwards, got another assignment from a credit union to appraise the same house. And they just copied the whole appraisal report essentially from the first assignment into the second one. And there were other problems. That threw up a lot of issues for the appraiser because they had done the work for someone else. That it brought up USPAP issues. They had not made clear that they never went and re-inspected. There's a lot of issues in the question that you brought up. Um, I don't know. I'd have to sift through each of them. Yeah. What are you thinking about it, Tim?
Well, Peter, what I was saying is, okay, we think of intellectual property as just that, something the result of the intellect. Well, you can go to the gym and you can lift weights, or you can go to the gym and watch people lift weights. You're going to the gym in both cases,
Hmm.
but in only where you lift the weights are you going to get the benefit. Um, so in this the second half of this hypothetical situation, you're using your own data. Nobody debates you
Yeah.
developed that. It's not even an
Hmm.
issue.
Yeah.
But can you claim it as intellectual property if there was no intellectual effort to get it? Because you expended all the intellectual effort on appraisal A, now you're just
Yeah.
expanding it or extending it
Okay.
to appraisal B.
Well, looking solely at the copyrights here, and the ownership of the prior work, looking solely at that issue, I would say that the appraiser can reuse that work for the first assignment in a subsequent assignment, that they are the owner of the prior work. And I would see no issue under copyright law or them losing the right to claim that it's their property because they've reused it. But then we introduce other problems. Maybe they promised in an engagement letter with the first client that the first client owned that work product, that analysis. Okay, now we might have a client issue there if the client discovered this and I've never seen that in the real world rear its head. And then, okay, maybe if the appraiser's completely reusing work from a prior report, possibly with some aspects of it, we might run into a USPAP issue, but I don't want to get too much into the USPAP because I know you're the expert on the USPAP side. But barring USPAP, barring a contract promise to the first client, I wouldn't see a problem with it.
Okay. All right. I appreciate your candor. Thank you very much. Um, let's take a look at um, okay, the uh, uh, the appraiser's having problems with the client, and the client just doesn't like the report. And I guess I should narrow this down a little bit further. This is not a GSE appraisal; it's a private
Mm-hmm.
one. Okay, so the appraiser says, okay, look, we're going to have to agree to disagree. I will refund your money, and this we'll just go back to square one. And the client says, okay, all right, that's fair. We're gonna do that. Now, the appraiser originally sold the client the report and all this stuff in it. Now the client, or excuse me, the appraiser is in effect buying it back. Now, the appraiser sends a check, the client cashes it, um, and everything's fine. And 6 months down the road, the appraiser gets a subpoena as a defendant, saying the client is suing you because you're an icky person and you did nasty things. All right. Having refunded the money, in other words, having bought the appraisal back, did the appraiser in any way eliminate or mitigate the client's ability to sue the appraiser? Or does that legal right exist even though the appraiser in effect bought the offending appraisal back?
So the client did use the appraisal. And it was
Apparently so.
later that, yeah,
Yeah, apparently 6 months later, apparently so. Yeah.
yeah. Um, no, by refunding the fee for the appraisal assignment, unless there was some other agreement, like a release from the client of this potential liability, without a release by the client, just simply refunding someone the fee for an appraisal assignment, as you said, buying back the appraisal, in all of my experience, that never gets the appraiser out of professional liability, negligence that relate to that appraisal report. So using kind of your scenario, I've seen appraisers, um, like a borrower threatens the appraiser, like, um, and and basically the appraiser refunds the fee to the borrower, and and I've seen that turned against the appraiser into, oh, the appraiser was admitting that there were problems with the appraisal. That's why the appraiser refunded the fee. So yeah, these fee refunds, they can be dangerous because they can be taken as admissions that there was a problem with the work product, and unless you're getting a release of liability back, that client or that borrower can still sue for negligence.
Okay, so short of, as
Mhm.
you say, release, then merely refunding the appraisal fee releases basically the appraiser from nothing, and indeed, it may open another door.
Yeah.
Okay,
Yeah.
all right.
I've
Okay,
also seen cases where the appraiser was never paid for the work at all. And so then the appraiser is sued by some party, could be a lender, could be a borrower. And the fact that the appraiser was never paid for the work has nothing to do with the negligence claim. They can still be sued for negligence in that appraisal report. It's
so not
disheartening.
getting paid. I'm sorry.
Yeah.
Go ahead. I'm sorry.
No, it's disheartening. I saw a number of those cases back in the last when mortgage brokers were ordering more reports, and a lot of times mortgage brokers a number of times would just not pay the appraiser for whatever reason, and then I still saw claims against those appraisers in relation to those appraisals.
Okay, so even though there might have been absolutely nothing uh, wrong, and I'm going to put that word in quotes with the appraisal, not getting paid didn't release anybody from anything. The appraiser was
No.
still responsible for it.
Yeah, that's true
Okay.
of any
Okay.
kind
All
of
right. Good.
professional service. It doesn't really matter whether you're paid for it or not. You can still be sued over it.
Okay. Thank you.
How
All
are
right,
we going to find some
Peter.
good news
As
today?
we wrap this up,
Tim,
um,
how can we find some good
mention
news?
good news today. You and I both had bad morning. Mention some good news. You and I both had bad mornings. So go ahead.
Well, I think on the on the side of things I work on the commercial side, that demand for appraisal services right now is looks like it's increasing a little bit on the different kinds of services that our firm provides. So I would say there's good news. I hope that's true on the residential side. Um, that would be a good piece of good news.
Well, for the residential, excuse me, for the commercial folks, that is good news. For the residential folks, perhaps the day is not quite so sunny.
Mm.
But I was going to, Peter, I was going to ask you as we finish up here, any word, anything more specific on some of the discrimination lawsuits that have been filed against appraisers? Anything new in any of those?
Um, Well, I think the good news is there is no tidal wave of discrimination cases against appraisers. We're still talking about there being probably fewer than 20 cases in court in the last 4 years uh, alleging discrimination by appraisers. So I think that is good news. Um, to put that number into perspective, 20 cases when in the last mortgage like negative cycle back in 2007 and 8 when property prices were declining and there were lots of mortgage defaults. The FDIC alone sued more than 700 appraisers during that time period. So that puts that 20 cases into real perspective. That's not a big number. So it suggests to me that there aren't hundreds even of borrowers out there waiting to sue appraisers over alleged discrimination in appraisal reports. So I think appraisers can see that as some good news out of that.
Okay, excellent. Peter, thank you very kindly. Appreciate it. Again, everybody, thank you for watching. Thank you for tuning in. On behalf of Peter and him and his family, let me say thank you for being here. We appreciate it. Peter, you're not in the position to take private clients anymore, are you?
No, I gave that up when I started my new job. Yeah,
Okay,
but I
all
still
right.
teach a lot of classes. Teach a lot of
And
classes, and mhm.
we're recording this toward the end of November. What have you got coming up? Where will people be able to go and see you?
I know that I'll be at the AXE conference in April. I think is that in San Antonio this year?
San Antonio, yes, huh?
And so on that subject of discrimination, there is a new requirement for appraisers nationwide, a new requirement from the AQB, 7-hour evaluation bias class. And all appraisers who renew their licenses after January 1 of 2026 are going to have to complete this new 7-hour class one time. After that, it's 4 hours. But I think in April at ACTS, that'll be the first time that I teach a new 7-hour valuation bias class.
Okay,
So,
I'm looking
yeah.
forward to that. I'll be there for that class.
Mhm.
Excellent. Anything else? Are attending any institute meetings or any meetings like that?
I teach a number of classes at Appraisal Institute chapters, and I do have, it'll be too late by, I'm teaching one this week for the Southern California chapter. And so I probably do 15 of those a year. Oh,
Oh,
different chapters. So in March, I'm going to the Hawaii chapter to teach a 7-hour kind of general appraiser law in the real world class in Honolulu
oh,
in
excellent.
March.
Excellent. Well, March in Bozeman or March in Honolulu. Not that sounds like a pretty good gig. I hope you get to spend a
Yeah.
couple of weeks there. All right.
Yeah.
Peter, again, thank you. I appreciate it. Peter Christensen, Esquire, attorney who understands appraisals and appraising. So, Peter, again, I thank you. And it's good to see you again. Thanks very
Yeah.
much.
Great to see you, Tim.
Thank you. We'll see you in April. And
Yep.
thanks, everybody. Bye bye now.